Bismillahirrahmanirrahim. Assalamu alaikum. My name is Dr. Harun Khan. On behalf of the IPA, I welcome you all on this webinar on wills and inheritance. IPA has designed this webinar to be understood by a layperson. The importance of the will become more significant since the COVID pandemic, and it is still there. Muslims living in a non-Muslim country are confused to make the will or not to make the will. To know more about this complex area of the Irish tax laws and the Islamic view on it, IPA has gathered the panel of the legal experts and Muslim scholars so they have a clear idea how their hard-earned assets can be disposed of to their loved one in life or after their death in legal and their own way. Before we go on a full capacity of the seminar, I like to tell you some rules of the house. Keep yourself muted. Ask question in English in the chat box. Answer can be replied in Urdu if requested. Session will be recorded. Format of this seminar will be, there will be an introduction of the IPA. There will be 5 speakers. They will talk on wills and inheritance, and the tax applies on the inheritance. And there will be a question and answer sessions. Now, I like to call Dr. Khalid Sarwar Khan, who is the president of the IPA, to introduce the IPA.
Thanks very much, Harun. And good afternoon, everybody, and Assalamu alaikum. I won't take your much time, and just most of you have attended our previous webinar and well familiar with IPA at this stage. But those of you who are joining first time, just for them a brief introduction. Next slide, please. So Irish Pakistani Professional Association was founded with a vision to guide and support the new generation. We are a group of professionals from different specialties who believe in collective effort to promote integration in our society without compromising on cultural values and beliefs, and to make Ireland a country where people can live with peace, harmony, and respect. Next slide, please. These are the main aims of the organization: to highlight the achievement of Irish Pakistani professionals and their contribution to the Irish society, to provide professional support and guidance to the young generation in Ireland, to help integrate the Pakistani and Irish community and also with other communities living in Ireland, to support community and welfare initiative and activities. And today's activity is part of this, the 4th aim we have. Next slide, please. Just to explain you a little bit about Irish Pakistani Professional Association, it's for the sake of doing our activities and for management purpose, we have divided into IPA Med and IPA Tech. Med is about 85% doctors in IPA, and that comprise mainly the Med, and also it has other health professionals which are either not doctor or but related to health system in Ireland. And IPA Tech has got ICT engineers, solicitors, business managers, ICT persons, and media persons. Next slide, please. I already highlighted, but just to give few things what IPA, MAD, and Tech are doing. They are providing guidance to our young generation. We've done lots of webinars and activities before, arranging academic and research events and helping them to improve their CV interview skills. And also we are starting a mentorship program. HPAT is a one event we've been doing it for a long time, as this 3rd time we have done, and to help the students interested in getting admission in medicine in Ireland. We also work in community benefit events and programs. Next slide, please. Now I'll just quickly screen through the events so it can give you a snapshot what we have done and what way we work. Next slide, please. This is the first inauguration event we have done on 23rd March, which is Pakistan Day. And by chance it came and we started. And if you can see, we believe in integration. This Apne team from UK came and they supported us. And also in that event, we have Irish culture represented with Irish dancing. So that reflects the aim of our organization. Next slide, please. We believe in family and involving the youth, and we organize events like family events. That was before COVID. It looks like a dream, but hopefully we'll get it done back again. Next slide, please. This is the first HashPad preparation course, which is for the students interested in medicine in Ireland. And it was for not only for Pakistani communities, for all communities, Irish and all communities living in Ireland. And it was very well attended and very successful, very good results and feedback after that. Next slide, please. Then the COVID came and everything was standstill, but we just gathered our resources and whatever we can help the community, both in Ireland and also at that time there was need in Pakistan. So we provided helplines to support the people, legal helpline, accounts helpline, medical helpline, and also provided rations in Pakistan and also PPEs in some areas in Pakistan where was needed. Next slide, please. Then I'll just screen through quickly. Then the second HashPad in August 2020, which was online. Next slide, please. And CV writing interview skills with very learned and senior professors in Ireland and UK as well. They guided the people how to get on the system and do the training posts. Next slide, please. This is a representation from 9 different countries. I would like you to represent Pakistan from Ireland. And we were talking about different system in 9 different countries, including UK, Canada, England, and other countries. Next slide, please. This is again a very important event of research and publication, which is a very key thing in the medical profession. And Professor Brandon Kelly, which is one of the top persons in this subject, has done this webinar and was excellent presentation there. Next slide, please. This is for, again, communication skill, which is a very part and parcel of medical practice. And at that time, Medical Council President Rita Brennan and Professor Peter Glynn, they all were involved. Rita Doyle and Professor Glynn were involved, and it was also very successful. Next slide, please. Upcoming event, we are planning to do some more events on communication skills and career in Cisco. Thanks very much.
Thank you, Khalid, for introducing the IPA. Now we will start the seminar by calling the speakers. Our first speaker is Faisal Sadiq Khan. He is a barrister in UK and is a practicing solicitor in Dublin. His specialty in making the will with understanding of Islamic values. I call Faisal Khan to start your speech, please.
Thank you very much, Dr. Haroon. Bismillah ar-Rahman ar-Rahim. Allahumma salli ala Sayyidina Muhammad. As Dr. Haroon mentioned, my particular focus is on Islamic wills. And without wasting any more time, I'll quickly just get into this. As you can see from our first slide, it is very clear from the hadith that it is incumbent upon every Muslim who has anything to request to not wait too long, not to wait even 2 nights without writing a will. And there's another hadith that all transactions by Muslims should be done in writing. If you move on to the next slide, I'll introduce the summary of my discussion is basically why an Islamic will. To begin with, obviously that is a fundamental question in everyone's mind. Then I will touch upon al-Wasiya because that is a concept very unique to Islam. And also tax planning, which is very important for when you're actually thinking of making a will, writing a will, or planning of your estate. And I'll explain slightly probate and also waqf, which is recently is lost its importance, although it was very regularly practiced by Sahaba. So if we move on to the next slide, please. Obviously, the main question is why an Islamic will, and I've listed 10 most common reasons. Obviously, there's a lot more than this. And to start off with, Islamic law on inheritance, it is very, very comprehensive, very detailed. It's obviously been going for 1400 years. The rules are set in the Quran, and there have been judgments and developments in this area throughout the last 1400 years. In fact, in comparison, the most or the closest comparison I can come to is that the Quran guaranteed women rights to property 1400 years ago, whereas in England, a wife was regarded as husband's property up until 1920s and 1930. Therefore, the Islamic rules are very vast, and they cover much bigger areas. There are a lot more judgments upon very novel, new, or different kind of issues that might arise in inheritance. Fundamentally, it is a religious duty, and a Muslim should do it according to the Quran as part of their faith. There are issues about inheritance planning. Obviously, you'd want to know whom to give what. In Islam, there is a greater emphasis on family cohesion, and therefore the inheritance is split up much more than amongst the just the wife and children. And this has the benefit of bringing families together, keeping them together. And in fact, the Irish family structure is very much geared towards that. And so Islamic wills in Ireland lend quite seamlessly into the Irish law, say for one or two exceptions. And obviously, making a will or making a timely will, it allows you to address the properties held jointly or mixed ownership. And obviously, from there onwards, you protect your assets for the beneficiaries. And utilizing Wasiya. Wasiya is something I'll touch upon in the next slide. And also the appointment of executors when children are not of age, or there might be an issue with the beneficiary not being able to deal with the bequest immediately, or due to some other incapacity. And to many Muslims, something that's very important is funeral wishes. So you make a will as to how your burial will be carried out, and other aspects attached to a funeral. And lastly, charitable gifting, which is quite entrenched in Islamic rules. So if you move on to the next slide, please. So why Islamic will in Ireland? The main reason for making an Islamic will in Ireland is that, firstly, it is incumbent upon a Muslim from the Quran, from various hadiths, and the rules developed by fuqaha, that a Muslim should make a will in accordance with the rules set by Allah Ta'ala and by God, and therefore for the blessings and mercy of the Creator, one should apportion their inheritance in accordance with Islamic rules. And the other aspect is that the Islamic will in Ireland is very simple to make. In fact, Irish laws of inheritance, because their roots are also in religious theology, they blend very seamlessly into Islamic inheritance. One of the issues that someone flagged up for me recently was that there is spouses' rights and legal right share in Ireland, whereas in fact in Islam the parents' rights, the rights of a surviving spouse are more important than the rights of children, even though the portions are different, but the rights of parents take precedence above children. Therefore, when such an issue arises, one should actually look for an answer within Islamic jurisprudence. And I have never seen a decision by any Muslim judge whereby they've allowed the surviving children to sell the house to move their mother or the father of the family home. In fact, it lends the other way. I've seen decisions where the judges have made it so onerous upon the children that they maintain their surviving parent to the standard that they enjoyed whilst their other partner was living. And obviously, it's a very big sin in Islam to move your parents out of their home. If we move on to the next slide, please. Al-Wasiyya is a unique concept in Islam, and so there's generally not a good understanding of what Al-Wasiyya is. The strict rules in Islam are that the 2/3 of one's estate will go to the blood relatives, and 1/3 of that, once an Islamic will is made, 1/3 of that can be given as the testator wishes. So this flexibility, it really gives one a great deal of benefit to a testator, where I've seen situations where even step siblings might have made great deal of sacrifices for someone, and they would not necessarily be, they would not fall within the rules of the estate, even in Ireland, or nor within the Islamic rules. Therefore, in order to compensate them, the wasiyah can be utilized, and they would then legally inherit property, whereas they might have lost out on something. Equally, stepchildren, foster children, distant relatives, or ordinary friends who might have contributed so much to one's life that one might feel that they need to compensate them in some way. Therefore, this particular aspect, the flexibility that this offers, it is not seen anywhere else in any other jurisdiction, in any other law, apart from Islam. If you move on to the next slide, please. Why make a? If you go back to the last one, why make a will in Ireland? In fact, fundamental question of the will: why make a will in Ireland? If you making a will focuses on asset protection, and it provides you tax savings. I think another speaker would concentrate on tax savings, so therefore I'll just briefly touch upon asset protection. So we move on to the next slide, please. Asset protection, when you're writing a will, it gives you opportunity to plan ahead, where there could be a number of issues. Sometimes there are some unfortunate circumstances in families. So every family knows their circumstances best. They know each other very well. Therefore, they can come to decisions as per as it suits them. Just as some example, it might be that you don't necessarily want to your child to inherit property too early. They might be not financially competent, or they might lose that property in a divorce or some other claim. therefore, you can structure trusts, and you can do. You can also have will trusts. These provide you considerable protection, and they also provide tax savings. If you move on to the next slide, please. Quickly on probate. Probate basically is that when someone passes away, someone has to deal with the estate, so they get it together. The law basically is that funeral rights have to be paid first, then debts, and then the assets need to be distributed to the beneficiaries. And this is normally done by solicitors. So if a solicitor drafts your will, they would ordinarily do this. And these matters should be discussed with solicitors in detail in order that there are no disputes after death. Moving on to the next slide, please. Waqf is something I really wanted to touch upon because recently it's lost its importance or its use, although as you can see from the quote from Jabir ibn Abdullah, that every companion to the Prophet whom was able to did leave something as a waqf. Waqf is another tool which not only allows you to give in perpetual charity, it also allows you to leave perpetual legacy, where sometimes children or spouse are not in a situation where they'll be able to manage or their affairs, and they can have income from a self-generating property, maybe rental property, or some other form of generating interest. And this particular aspect was considerably used by Muslims around sort of, 10th century, in that a lot of universities came about by waqf. In fact, the very first university in the world came about by waqf funding, and it provides a great deal of social benefit. So it not only generates income, but it provides a greater benefit to the society as a whole. And it's something that Muslims should consider because it's a religious duty of a Muslim to look after your fellow brethren. And obviously the society that you are in, you should benefit that society regardless of where you are. And therefore, it is incumbent upon a Muslim to provide a greater benefit, not only just for his family, but to the society as a whole. We move on to the next slide, please. Oh, okay, that's someone else's slide. But if you move back, I'll conclude my brief introduction to Islamic wills. And I think if there are any questions, I'll be happy to take them now or later.
Thank you, Mr. Faisal Sadiq Khan Sahib. It was really concise and to the point. And as you said, you well said, Islamic inheritance laws are existing well before any country inheritance law. The next speaker is Mr. Mujibur Rahman Ewan. He's a practicing solicitor in Dublin and is a notary public. And his topic of discussion is the welfare of the children if the tragedy to the family happens. Mujibur Rahman sir.
Assalamu alaikum, everyone. Thank you very much for inviting me for this talk. This is very important issue, I believe. That's why I recommended it. But it is a totally separate topic, which is normally we are used to here in the family matters. It is unique in its nature. So my topic, why a guardian is important. You know, there are many situations. If I go one by one, that will take very long time, but due to the time restrictions, I actually kind of made few headlines so I can discuss those. A guardian must be readily available to care the children in case if a parent's, I will say, I will use the terminology parents. In some cases, if there is a single parent, that means as well. So if they've actually fell in a coma situation due to some accident or otherwise become incapable to care and make important decision for the welfare of their children, then the guardian actually take over the parental responsibility for the welfare of the children. In many cases, we have seen that the children were left without care because, especially in Ireland, people are coming from the different countries to work and study, and they have no other close family members. And if anything happens to them and the children goes into then social care and finally in the foster care. For example, if there are 2 or more children in a family and they have this, God forbid, this type of situation that they'll lost their parents, and in that situation, it is very difficult that all those 2 or 3 children will be given in single care home. Those care could actually go into the different household. So the siblings will be divided. Plus, no parents wants that their children grow up in a situation other than their wish. That's why I recommended to everyone that they should, because end of the day, we have to die. And especially if we don't have very close family member, for example, our children's grandparents, our uncle, aunties, then they must have something in place to cater this emergency situation. There are few benefits to for appointment of a guardian in advance of any emergency situation to ensure to keep all the children together in same household. In a household of parents' own choice. And parent can choose a guardian of their own choice. So they can choose that Mr. A, B, or whatever the case, male, female, they can actually choose as a guardian of their children in their life. And especially when they are in a decision-making position. Parents can achieve the best interest of their children by appointing guardian in their life before any calamity happens to their life. So it is very simple because many you will see in the will, there is a clause for the appointment of guardian, and sometimes it delays the care of the children, and sometimes it has been witnessed that wills for some reason fails, and then there are many complications. So there is, in Ireland especially, there is a provision that a parent can appoint a guardian by making a statutory declaration. And that statutory declaration is accepted by all the authorities without any question, and the children are given into the care of that appointed guardian or declared guardian. So I will say, I said mainly the main issues of the welfare of the children and covering the emergency situation. If there is any other question, I will be happy to answer, but I will conclude my talk at this point.
Thank you very much, Mujib Sahib. Really is very interesting to know. And I just witnessed one of the incident which happened, and where both children who were age of 2 and 4 lost their parents within 48 hours. The father was going on a walk and he got a fatal accident, and then the mother did the suicide because she can't tolerate this loss. So this talk or this presentation may help to provide this solution of to other families, at least prepare for those kind of the incident that should not happen. My next speaker is Joanne Hoban. And my next speaker is Mufti Zakaria. And Mufti Zakaria is the Islamic, he's a well-known Islamic scholar who has been teaching and guiding the Muslim community in Ireland for the last 10 years. He's postgraduate in Islamic jurisprudence from Islamic College in Johannesburg in South Africa. And he will talk about the Islamic values and views on the will. Mufti Zakaria.
Assalamu alaikum wa rahmatullahi wa barakatuh. Jazakallah khair, Dr. Khan. And my warmest greetings to our panel members and to the rest of the participants today. So thank you for joining this very informative and educational webinar on inheritance and wills, which is also covering the Islamic aspects, which are so important in this day and age and have always been very important. As Faisal earlier elaborated, mashallah, quite well on how beautifully the Quran, as well as our Sharia, has given each heir their right of inheritance, and how detailed and elaborate the Sharia is when it comes to covering the subject of inheritance, and also regarding preservation and protection of your assets and looking after your loved ones after one passes away. As we know, Islamically, Allah subhanahu wa ta'ala has already preordained and fixed the shares that will be allocated to each person from the family members of a deceased person. And these shares can never be altered. As Allah Ta'ala mentions in the Quran, فَرِيضَةً مِّنَ اللَّهِ. We all know that fariḍa means something that is an obligation. It is incumbent, and it's something that cannot be changed in any way. So we are duty bound to following the Quranic injunctions and the Quranic guidelines. And people often ask that, can we do that also living in a non-Muslim country? So there is no contradiction over there, because a person has the prerogative to make out a will during their lifetime and allocate whatever they wish to whoever they wish. Yes, the dispute can come about if somebody is completely disinherited, and then there could be a case where there will be a dispute, and there could be lawsuits, or all sorts of issues of litigation can follow, I suppose. But if everybody is conscious of the religious obligations, and if everybody is on board to follow the Quranic instructions and what the Sharia has outlined in terms of the shares that each person will receive from the estate of the deceased person, then there should be no problem really in the devolution of the estate of the person who has passed away. So when a person passes away, typically there are three most important things that are done. One is that the funeral expenses are first paid for from the estate of the person who has passed away. And thereafter, we will see whether they have left any debts which need to be paid out from the estate. If after that, if anything is left, then we will see whether he has made a wasiyah, as Faisal has mentioned. So if there is a bequest that he has made, and it's also mentioned about waqf. And this is something very important that each one of us in our lifetime, I always feel that if you can do this in your lifetime, and maybe, we learn of scholars and the greats of the past, our predecessors, who actually gave away their entire wealth before they even passed away. And they had this agreement between their child or their spouse that, look, whatever I'm using, I'm only using it, I'm only I'm borrowing it actually of you. I'm using with your permission, so that when they passed away, there was nothing, to even fight over. There were no disputes that they would even leave behind. Nevertheless, alhamdulillah, we know that the Quran has made it very clear to us and given us a very perfect guideline and instructions over here. So a bequest should be made, I feel, for 1/3 of your wealth, and that from that 1/3 as well, if a person has religious obligations that they have not yet fulfilled. For example, a person needed to perform the Hajj, the obligatory Hajj, and yet they did not perform the obligatory Hajj. So that can also be made as far as 1/3 of the residue of a person's estate is concerned. Thereafter now, the 2/3 remaining of a person's estate, after the funeral expenses have been taken out, after any debts and loans have been paid off, and the bequest has also been seen to as well, the wasiyah has been implemented. Thereafter, whatever remains will be divided amongst the heirs, the Quranic heirs of the deceased person. So, a few things that I always mention, and once again, I keep referring to Faisal's introduction speech there, and mashallah, he mentioned about how the Quran so fluidly mentions about women's rights in the surah, in the chapter of the Holy Quran, where the laws of revelation, laws of inheritance have been revealed. So the background to the verses of inheritance, it is said that it was the widow of Sa'ad bin Rabi' radiyallahu anhu, who came to the Prophet sallallahu alaihi wasallam complaining that my husband has passed away and I am left with my 2 daughters, and the cousin of my husband has come and he has taken everything and left very little for me. What do I do? So immediately the Prophet sallallahu alaihi wasallam turned to Allah subhanahu wa ta'ala. The revelation came down, and the Prophet sallallahu alaihi wasallam admonished the cousin and said and told him that no, you are to give 1/8 to the widow of Sa'ad bin Rabi', and 2/3 of his estate will be given to the daughters, and then the remainder of the estate will be divided amongst other family members. So alhamdulillah, Islam has 1400 years ago protected the rights of orphans and protected the rights of the females who were considered vulnerable and weak in society. But they were, and in the surah, alhamdulillah, once again, Allah Ta'ala makes it very clear, لِلْرِجَالِ نَصِيبٌ مِمَّا اكْتَسَبُوا وَلِلنِّسَاءِ نَصِيبٌ مِمَّا اكْتَسَبْ, that for the males, it is their right and they have complete control and authority over what they have earned. And similarly for the females as well, they have equal rights exactly to what they own and what they possess. So alhamdulillah, these things should never cause any sort of confusion and should never create this doubt in our minds that women have been classed as second or are considered second-class citizens. Also, we should all know, and alhamdulillah, we know this, that Islamically, it is never the duty or the obligation upon a female to even see to her own needs as well. Even these have to be looked after by the males in the family. So whether it's the father, the son, the husband, the spouse, the brother, and in the absence of them, other distant relatives would have to look after the women in society, regardless of whether they own their own wealth or not. So alhamdulillah, in that respect, our sisters, mothers never have to worry about these things. So anyway, when it comes to the implementation of a person's will, it's important, especially given the context and the countries that we live in over here, because the default over here is never going to be the Islamic law. If we leave this world without a will, then the default is always going to be the state law. So that's why in our last testament or last final will, we cover the Quranic shares that Allah subhanahu wa ta'ala wants us to allocate to each individual heir of ours. And this is something that should be stressed upon, and this is something that is extremely important. And I appeal to one and all to ensure that we make that will which protects our wealth, and our wealth is then given and divided amongst our children, our partners, our spouse, the husband and the wife, they get their rightful share of the estate, the children and the parents as well. The verses of the Quran, in fact, speak about, first and foremost, speak about the daughters and what they will receive, then about the parents, what they will receive, and then the spouses. And then after that, when these shares, these principal shares, these fundamental shares, once they have been allocated, then the rest of the male offspring, the sons, they will receive their share. And then in the absence of close relatives, primary inheritors, in the absence of them, then distant relatives will come into the picture, and then they may inherit. And at the end of all of this, subhanAllah, Allah subhanahu wa ta'ala makes it very clear. And this further, usually, when we're talking about the conclusive verses of any kind of chapter, we tend to just recite them and we don't really focus or reflect too much on them. But here Allah Ta'ala says, وَتِلْكَ حُدُودُ اللَّهِ, that these are the limits of Allah subhanahu wa ta'ala. وَمَنْ يَتَعَدَّ حُدُودَ اللَّهِ, Allah Ta'ala says, these are the limits that have been set out by the Quran and by Allah subhanahu wa ta'ala. And whoever oversteps and transgresses the limits of Allah subhanahu wa ta'ala, then for them there will be a painful punishment in the hereafter. وَمَنْ يَعْصِ اللَّهَ وَرَسُولَهُ وَيَتَعَدَّ حُدُودَهُ, whoever disobeys Allah and His Messenger, peace be upon them, sallallahu alayhi wa sallam, then وَمَنْ يَعْصِ اللَّهَ وَيَتَعَدَّ حُدُودَهُ يُدْخِلُهُ نَارًا خَالِدًا فِيهَا, or they will be entered into the hellfire. وَلَهُ عَذَابٌ مُهِينٌ, and for them there will be a very painful and humiliating punishment in the hereafter. So that is why the scholars say, that the ulama say that not following the laws of inheritance is actually akin to kufr, akin to disbelief as well. So we have to be very careful in this matter, and not only ourselves, but I think more importantly, even family members who are survivors of the deceased person, they have to make sure that a person's wealth then is distributed correctly as per the Quranic injunctions. Anyway, I'd just like to conclude on that. And at the end, inshallah, I'm more than happy to take any questions as well.
Thank you, Mufti Zakaria Sahib. Really, it was a very explanatory and very clear. There are a lot of concept about the Islamic view on wills. Now, my fourth speaker is the Joanne Hoban. She's a practicing solicitor at Capel Street, Dublin, and she's specialized in wills and the trust and estate, family law, residential and commercial properties. And she recently did the fellowship in the trust and the estate practice. She is going to talk on how to prepare the will. Joanne, please.
I was just figuring out how to unmute myself there for a second. Hello, everyone. Good afternoon. Thank you very much for inviting me on, Dr. Khan, and for so eloquently introducing me. I need say no more other than in my day-to-day practice, I'm involved in preparing wills and advising on the creation of wills pretty much on a daily basis. And obviously in the context of my other work in relation to land, property and family law, wills, estates and the various laws, Irish laws in particular surrounding property come into my work as I go through it and as I advise people on an ongoing basis. So what I'll try to do today very briefly is to go through the very simple steps in preparing for your will, because a lot of people, when they come in to see me, they're quite nervous and they really don't know what to expect. And they're generally quite apologetic because they haven't prepared anything. And it's a common thread amongst people to be a little nervous about preparing your will. So, so what I try to do is I try to accurately reflect your wishes, but also I have to make sure that the will is drafted in compliance with Irish legislation and also to make sure that it's as tax efficient as possible. Obviously, if it's a straightforward will, you know, I'm happy enough, I can advise fully, but obviously there can be some very complicated wills which require a consultation with a tax expert or accountant. And I suppose the first thing I always talk to about people in order to mainly break the ice is funeral arrangements. You know, that would form part of a lot of wills. You know, more so as you get on in age, it's something that that comes up a lot, and people like to address. And then secondly, I go through the various assets, and you know, to short circuit things, and to ensure that when you go into your first consultation for a will, a good idea would be to kind of, you know, sit down at home and go through what you have, so that you know what you have, because a lot of people don't really think about it. And I will advise people, you know, when you've made your will, or when you're about to make your will, get your bank statements, know what's in your bank accounts, know what life policies you have, shares, investments, you know, items that you want to leave in your will, and have a list, and then I suppose find a box at home and keep them safe somewhere with the will. So that's a hugely important thing to do if you're making your will. And then in the context of the consultation, I will move on to executors, trustees and guardians. So that's kind of the next topic of discussion. And most people who come into me, they really, well, some people know straight off who they're going to nominate, and other people really haven't a clue. And oftentimes it delays the will being created, because, you know, it's sometimes can be a very difficult decision. You know, especially if you have young children, I will always advise that 2 executors be nominated. In fact, in all cases, 2 executors is really important. You know, if somebody can't act or someone has predeceased you. And then trustees, you know, often they might be the trustees will manage the trust that you create, if you are going to create a trust. And oftentimes the trustees and the executors are usually the same person, same people. And then generally people, if they're appointing guardians of young children, you know, it's more likely that you'll appoint separate guardians and separate trustees and executors, because obviously there's a potential conflict of interest if you're a guardian and you have access to the money. You know, so taking care on a day-to-day basis of children is a big job. And you know, you'd have to trust your guardians implicitly if you're going to provide them with access to the trust fund for young children. So that's executors, trustees and guardians. And then as well, I will always make sure that I cover joint property. So say, for example, if a husband and wife comes in to see me, you know, I'll ask them, what's joint? You know, what is jointly owned? Is your house jointly owned? And actually our obligation now is, you know, generally as a solicitor, we're required to go and find proof of that. Because if it's not jointly owned, you know, a big mistake can be made in the context of creating a will. And jointly owned property generally goes by way of survivorship. You know, so it doesn't actually even have to go into your will. The same with bank accounts and, you know, spouses, maybe people who are getting on. You know, it's very important, I would say, to keep your bank accounts in joint names, you know, or a bank account in joint names, so that the person, the survivor, can carry on and not have to worry about administering an estate, you know, in the aftermath of a predeceased spouse. So that's another huge area, and there's a myriad of different types of situations that can arise there, and different types of advice that I can give. And then speaking of spouses, in Ireland we have this the big requirement, which is the legal right share. And so this legislation, which is, has been around now since 1960, or so it's 1965, prevents the disinheritance of a spouse. So, so it's really important to ensure that I advise people that the spouse is entitled to the legal right share, which is half of the estate if there's no children, and a third if there are children. So no matter what you leave to your spouse in your estate, your spouse is entitled to that amount in Ireland. If you don't have a will, the estate goes entirely to your spouse. Or 2/3 of it go to your children. 2/3 of it go to your spouse, and 1/3 to your children if you have children. So that's another really important point, because that 1/3 going to your children if you don't make a will can potentially be a big problem, because it would mean that your children will stand to receive 1/3 of your estate at the age of the tender age, I would say, of 18, which is not always advised. So, that again shows the importance of creating a will. And then in the context of children, when people come into me, they want to provide for their young children. I'll give a general idea at the meeting about, how to create a trust for those children in the context of your will. And you can provide for the children by way of a trust up to the age of 18, or you can go onwards up to 21, up to them completing full-time education, and onwards up to 25 and 30 if you feel the need. But as I said, there are significant tax complications there. And it is a big decision, and it's something that I would address in the context of the meeting. It's something, obviously, that a lot of people go off and they have to think about it, and then they come back again before they draft the will, about what age their children should benefit in their estate. And then, unfortunately, I have to address with people the idea that maybe you might want to leave out a child. And that's where it gets quite complicated. And, I'm obliged to advise that under Section 117 of the Succession Act in Ireland, we have what's called the moral duty to a child. And as I think my colleague was talking about, its potential interference with parents' rights. The moral duty to a child cannot interfere with the legal right share to a spouse. So, so it can interfere with other benefits that you leave, but it can't interfere with what you leave to your wife or your husband. Then under Section 117, if you decide to leave out a child, my obligation would be to take a really, really good note of it, to ensure that I advise fully about the potential ramifications of a claim against your estate by a child who feels that they've been done out of something that they're entitled to. And oftentimes I require my client to prepare an affidavit detailing the very specific reasons why that child might be left out, be it, it might be that they've already been adequately provided for during their lifetime. They might have a significant disability, or there could be, some other issues, that simply mean that they should not be provided for. And then almost finally, at the end of every will, it's very important to cover what's called Section 63 of the Succession Act, which deals with lifetime gifts. So under Section 63, if you provide equally for all of your children, and one of them have received a very large gift during their lifetime, that large gift is deducted or credited towards the benefit they receive. So it means it reduces the balance that they receive on death. So you can, if you want, in your will, you can discount that section, and you can say that that section won't apply. So it will mean that, you know, all your children are starting off on a clean slate. So that's another important section to cover in wills. And then I hope finally, in relation to wills, I often meet people who you know might be getting on in life, maybe in 50s, 60s, possibly 70s, and even 80s, and as well as that, people who are, you know, have the type of jobs that, or you know, might be business owners that need the business to carry on if, for example, they lose capacity. So I will always advise people about the possibility of putting in place what's called an enduring power of attorney. And this is a document which is, I wouldn't say it's quite straightforward, but it's quite efficient to do it along with your will. Because, you know, a lot of the instructions in relation to it are quite similar to the creation of a will. And, you know, it's like, you know, you're doing the two at the same time, and it really cuts a lot of extra work if you were to come back and do an EPA at a later date. So I'd always advise people to do it. And it does help as well from my point of view, because, you know, my job is hugely about assessing capacity and carrying out the legal test of capacity. But I also have to, especially when the people are getting on, you know, people who might be unwell, or, you know, creating wills when they have an illness, that I generally will require them to attend a doctor in order to obtain a certificate confirming that they have capacity to conclude a will. And I would as well, I would generally ask them, you know, that, you know, why not do an EPA at the same time? It's a really good tool. And what you're doing in the context of an EPA is that you're appointing attorneys to act in your stead. So they basically step into your shoes. They can sign all relevant documents. They can do everything that you can do. You know, and as well as that, you can limit it if you want to. So you can say, you know, you can put in the EPA, well, I don't want them to sell my house, or, you know, I want them to make sure that I reside in a certain nursing home, or that I don't, you know, that I stay at home for as long as possible. Things like that, you can limit it, and you can give them direction as well. So it's a really good tool, and it's a good thing to do along with your will. There are huge changes coming in the area, but as it stands, the EPA is there. It confers the right on your attorneys to deal with your assets if you lose capacity. And the benefit of it as well is if you do have a significant estate, or if you have significant assets, you know, it's a lot less expensive and a lot less cumbersome than the word of court process, which in effect means that, you know, your family and your potential attorneys would have less, you know, less power over your assets, and less power over your care. So I would think DPA is a very, very good thing to do alongside your will. And finally, you know, the very final thing I'll talk to people about is safekeeping. And you know, what we do is we keep most wills, you know, the majority of wills, and there's very few people who take them home nowadays. But the majority of people will leave the will with us. We're very heavily regulated now by the Law Society. We have a specific register. We keep it on the system. We have safe, or most solicitors nowadays would have safes where they keep the wills, and we'd always advise our clients to review them every 2 years, or in line with tax changes, to keep in contact with your accountant, and to ensure that, you know, you're watching for changes that come. that might affect your will during your lifetime, requiring you to review it. So that's me, Joanne.
Thank you, Joanne. Really very impressive presentation. Really, you explain well in simple words how to prepare the will, and particularly you well explained the importance of the EPA and the capacity. The will is a complex issue and really hard to understand every step of that. The Irish Pakistani Professional Association tried to clear the doubts and trying to realize the importance of the will to make it in your lifetime. And because, as John said, in one of the cases, we ignore that very simple scenario which can happen to anybody, not a Muslim married to the non-Muslims. And when the non-Muslim died, if there is no will, the funeral arrangement is a question. And I have come across a few families who they have no really will, and they don't know to bury him or cremate him, as all depending upon the person, the survivor family. Anyway, we can talk as much as the time is very short. So we will go to the next speaker now. And as we know how to make the will, as we know if the will is made and the person is passed away and the inheritance divided, now the question of the tax comes. So for the tax expert, we have Martin O'Dowd. Martin O'Dowd is a practicing accountant in Lucan for many years. His area of the experts are tax on inheritance and the VAT and the company formation. Martin, the mic is yours.
Okay, thank you, Dr. Khan. Good afternoon, everybody. I suppose just a question for the two solicitors, Faisal and Joanne, before we start, and it's something that's only occurred to me as we're going through listening to the speakers today. My father died 40 years ago, and he had taken ill suddenly, was admitted to James's Hospital. And by the time he got to the front door of James's, and by the time he was operated on, he had made an emergency will, okay, because he hadn't made a will prior to that. It was laid out in the proper format, and he got as witnesses a doctor and a nurse in James's who weren't obviously beneficiaries under the will. In time, he died 3 weeks later, and in time that will was deemed valid, but only because the witnesses had not been beneficiaries under the will. And it might be something we circle back to. You know, are there circumstances where an emergency will can be made in a hurry and still be valid? And especially in COVID times where people are, you know, admitted to hospital and you don't know what's going to happen. I know it's kind of a curveball to throw at you, but it could be relevant in circumstances. Having caused that chaos now, I'll go on and do my and give you a chance to recover. Okay. I suppose the most important thing here is it's important to make a will. It's important to go to the solicitor to make the will. The process might be easier if you have a business and you have a lot of assets. If you go and you pre-plan your will with your accountant, they can go through the various permutations and combinations, and it will probably make your visit to your solicitor and legal advisor much more productive and shorten the period of time involved in getting your wishes legalized and down on paper. Transfers between husbands and wives are tax-free always. Transfers to children, each child can inherit $335,000 under current legislation from their parents. That's a combined $335,000. I just see from some of the questions that are coming up in the chat as to whether it's a lifetime or whether it's for each parent. It's for each child, and it's a combination of parents. So it could be 200 and 135 or vice versa, but it's per child and per combination of parents. For blood relatives, they can inherit 32,500 from each other. Again, it's a lifetime threshold. And for strangers, they can inherit 16,250 from each other. Anything above that is taxed at 33%. If you inherit business assets or farm assets in certain circumstances, the valuation drops right down and the tax by 90%. So the effective tax rate is 33%. There are various reliefs that are available for that, but you have to hold the assets for 5 years or 2 years, depending on it's a gift or inheritance. 80% of your assets have to be agricultural if you're claiming the agricultural relief. And that's something where, say, a medical consultant might have 2 million in the bank and 1 child. If they leave all their assets to that child, it's taxed at 33% on anything over 335,000. If they had bought a small hotel and met the time guidelines, that the value of that hotel will pass at 3.3%. So there's an element of tax planning that can be done in converting cash into business assets. Anyone can receive 3,000 from anyone else every year under the annual exemption. So you can get 10 gifts of 3,000 from 10 different people, and you get those tax-free. And that's an important one, because if you start doing that now, you can diminish the value of your estate right down. Sometimes, if you transfer an asset to a family member, it might be an investment property, for instance, and you transfer it and it's valued at 335,000, you transfer it to your daughter, your son, they get that tax-free. But that might have only cost you 200,000 or 300,000. The difference between the value you acquired of that and the market value will be taxed on you in capital gains tax. The capital gains tax rate is 33%. If, on the other hand, your son and daughter on such a transfer is liable to capital acquisitions tax, they will get a credit for whatever capital gains tax you have paid on the same transfer. So there is not double taxation on the transfer of any asset. If you've paid capital gains tax, they get it as a credit. So the capital gains tax isn't wasted. Something that came up during the week was if I'm living in Ireland and I receive a gift from abroad, so I receive a gift from the UK or Pakistan or wherever, am I taxable on that gift? And the answer is, if you're a tax resident in Ireland, yes, you are taxable on that gift. The thresholds will apply. So if it's under the threshold, you don't pay tax. If you have paid tax in the foreign country from where you got the gift, and there's a double taxation agreement with Ireland, well, then you get a credit for whatever tax was paid abroad. Pakistan has a double taxation agreement with Ireland. So if you did pay tax in Pakistan on a gift that you got in Ireland, you get a credit for any tax paid in Pakistan. Other things, as Joanne said, you need to review your will every so often. You know, a married couple starting out in life with no children, and they're lucky enough to have children, they need to change and make a new will to reflect their current circumstances. And as their assets grow and their business grow, they need to keep constantly changing their wills. Another very important point is, let somebody know where your will is. There's no point going to Joanne or Faisal and making a will, and then you pass away and nobody knows who your solicitor is. So it's important that, yes, you might have a copy at home to make sure that that's the last copy, but also let somebody know where your will is so they happen to be running around looking for it, and let them know who your last solicitor was. That's also important, because sometimes people change. And one thing we covered somewhere else is a letter of wishes. And a letter of wishes has two reasons. You may have assets that are of sentimental value, or you may have other assets like jewelry or paintings that are hanging on a wall. If it's done right, they can be transferred by way of letter of wishes, depending on their values. And you can deal with it outside your will and let people know, well, my daughter's to get my wedding ring, my son is to get my favorite fountain pen, and your favorite accountant is to get the Rembrandt. That's just something you need to discuss with your solicitor as well, because some things can transfer technically without going through the will if they're movable property. Again, just to summarize, I'm almost finished, but just to summarize, the thresholds are lifetime thresholds. They do move up and down. For instance, the 335,000 threshold was 500,000 until the recession came along in Ireland. They have started to move up again. So if you're putting in your will clauses that just match with the threshold, you need to look at it every budget to see whether it has gone up or down, and then your will needs to change. And other than that, I don't really have much more to say, but happy to take any questions.
Thank you, Martin. Really helped us to decide what to do when the inheritance divided. Now there is a topic of discussion, and is can I have the next slide, please? Yeah. As this is a common topic in every family, and what to do if suppose if there is a no will or will, and how the Islam has Islamic decision is done on the wirasat or everything. So that is done. The excellent work is done by the Hidayat Mirza. He wrote a book in Urdu on property and inheritance, and I like to play his video clip, what he's saying.
तो मैं आप सब हज़रात को इस चीज़ की मुबारकबाद पेश करता हूँ, बिलख़ुसूस इस महफ़िल के मुंतज़मीन को कि जिन्होंने इस अहम मौजू पे इतने अच्छे इज्तिमा का इंतज़ाम किया है। अल्लाह ताला आप सबको इसकी इजाज़त दे जिन्होंने इंतज़ाम किया, और आप लोगों को जो आप सुनने के लिए आए, क्योंकि दरअसल ये शरीयत का ऐसा फ़र्ज़ है कि जिसके बारे में जितनी मालूमात हासिल की जा सके उतनी ही कम है। ये वो वाहिद एक फ़रीज़ा है कि जिसके मुतल्लिक़ अल्लाह ताला की ज़ात ने ख़ुद तफ़सील के साथ कुरान में इसका ज़िक्र किया है। अगरचे के फ़राइज़ के लिहाज से नमाज, ज़कात, हज, सियाम, रोज़े, सब रमज़ान, सब ये फ़राइज़ हैं, लेकिन किसी की तफ़सील इतनी जामियत के साथ बयान नहीं की गई जितनी इस विरासत के हवाले से कुरान पाक में। और यकीन करें सिर्फ दो आयात हैं मेन सूरत आल इमरान की जिनमें इसकी पूरी तफसील है। बहरहाल इसकी वजाहत के लिए ज़ाहिर है उलमा इकराम ने बहुत काम किया है, शरीयत की और भी आप सल्लल्लाहु अलैहि वसल्लम की अहादीस से भी इसका हवाला लेना पड़ता है। तो मेरे असल में इस किताब लिखने का मकसद दो तीन चीज़ें थी मेरे जहन में। एक तो ये थी कि चूँकि ये फ़र्ज़ बहुत अहम है, और जितना ये अहम है आम लोगों में इसकी अहमियत का बिल्कुल एहसास नहीं है, बल्कि अमल इसके बिल्कुल ख़िलाफ़ है। तो इसलिए मेरी ख्वाहिश थी कि कम से कम इसको उजागर किया जाए। मुझे मेरे शेख ने इसकी हिदायत फरमाई थी कि आप इसके बारे में कुछ लिखें, तो बहरहाल मैं बड़ा उनका मशकूर हूँ कि मेरी तवज्जो इस तरफ आई, और मैंने काफ़ी रिसर्च की अपनी तरफ से। ज़ाहिर है उलमा इकराम ने इस बारे में बहुत कुछ लिखा है, मेरी तो हैसियत ही इनके मुकाबले में कुछ नहीं। मेरा सिर्फ ये काम है इस किताब के लिखने का कि इसमें अव्वल तो लोगों की तवज्जो इस तरफ दिलवाई जाए, दूसरा मकसद ये है कि जो इसके अहकामात हैं उसकी वजाहत के लिए सादा ज़ुबान इस्तेमाल की जाए ताकि लोगों को इसकी समझ आ सके। क्योंकि जो किताबें जो मवाद इस सिलसिले में शाया है इस वक्त अवाम की नज़रों में है या उलमा इकराम की जो नज़रों में ख़ास तौर पे, उनकी ज़ुबान इतनी मुकफ़्फ़ा मुजस्सी यानी ये मुश्किल है कि आम आदमी उसको समझने से कासिर है। तो मैंने उस ज़ुबान को सादा किया है, ये भी इसलिए कि ताकि हर आदमी इसको समझ सके। और जो इसकी तीसरी वजह जो ये है कि इसके बारे में कानून के विरासती कानून के बारे में बाज़ गलतफ़हमियाँ आम हैं कि इसमें ख़वातीन का ख़ास तौर पे कि उनके हकूक़ पे ज़द पड़ी है और उनको सेकंड क्लास सिटीज़न के तौर पे इससे उनके खिलाफ सलूक किया गया है। तो इस सिलसिले में मैंने गलतफ़हमी को अज़ाला करने की कोशिश की है। ज़ाहिर है इसमें मेरी तरफ से कोई मुआद नहीं है कि मैंने कोई कानून नया पेश किया, खुदा माफ़ फरमाए इस इतनी जसारत के लिए। तो बहरहाल मैंने तो सिर्फ जो उलमाए किराम ने जो शरीयत इसका हुक्म देती है, मैंने वही चीज़ें मैंने सादगी से बयान की। तो अल्लाह ताला आप सबको इसके जज़ा दे, और जिन जिन लोगों ने मेरा साथ दिया इस काम के लिए मैं उनको बहुत शुक्रगुज़ार हूँ। और अल्लाह ताला से दुआ है कि जिन्होंने भी जिस हैसियत से इस काम में हिस्सा लिया, अल्लाह ताला उनको इसका जज़ा दे। बहुत बहुत शुक्रिया। और मुझे खुशी है कि इस महफ़िल में ख़ास तौर पे उलमाए किराम भी तशरीफ़ फरमा हैं और प्रोफेशनल भी हैं, तो उलमाए किराम इस सिलसिले में ज़्यादा मेरे से बेहतर तरीके से इसकी वज़ाहत भी कर सकते हैं। तो बहुत बहुत शुक्रिया। अस्सलाम वालेकुम।
Now we come to the next stage, the question and answers. And Irish Pakistani Professional Association trying to make the will simple way and explain the all technical and difficult words to explain in a simple way. There's a lot of questions we have received by the emails and by the chat box. And I can see here in the chat box, our legal experts are explaining the lot of questions, but still few questions they are there. Can I ask first question to Joanne, please? Can mother give separate inheritance, and can father give the separate inheritance? Or is the 3,000 euro per child, mother can give as well, or the father can give as well? Can you unmute, please, Joanne? Khalid,
give me a few moments. I am just unmuting her. Joanne, can you try unmuting yourself? Yeah, you're unmuted now.
Yeah, sorry, I wasn't allowed there for a minute.
Joanne, did you hear my question, or will I repeat the question?
Yes, no, I did hear it, and it's actually been addressed a bit in the chat as well, and they're both very important points, and Martin will reiterate. It's something that actually I couldn't get my head around for a while as well, and I actually remember at one stage I had to ring Martin about it because I was a bit confused. It's per person, so it's per beneficiary. So the Class A threshold is 335 at the moment. Obviously, it goes up and down, or it has gone up and down. But the Class A threshold of 335 can only be hit once by each beneficiary. So each child will have one threshold each. And that threshold can come from either or both parents. So it might be a mixture, as Martin quite rightly said, it might be 100,000 from the mother and 200 from the father, and etc. And that's how it's made up, but it is only once. And the other thing as well that Martin, I know, will talk about, obviously it's not just about advising on a will, it's about advising on how to be as tax efficient as possible during your lifetime. So, so I'll always think back about how to do things during your life. And there is the provision, the small gift exemption, which is a 3,000 euro small gift exemption on gifts that you provide during your lifetime to anyone. So in other words, so you can, as opposed to giving it on death, you can open a bank account for a child or a grandchild or a group of people and give 3,000 per year into that account, so without tax. And it actually doesn't mount up for your threshold. So in other words, it doesn't go towards the eventual threshold of the 335. So it's a really, really good way of keeping within the rules and allowing yourself to to pass on cash. And it has to be cash, I suppose. Martin might tell, it might be something other than cash, but cash is what I usually advise on, that you can do it every year, and it obviously mounts up and it can become a substantial sum tax-free.
Thank you, Joanne. It is another question I think is related to you. What you advise dealing with the specific items of property such as jewelry, painting, and other personal items?
Yes, so I think, again, Martin alluded to jewellery and to paintings and all of those kind of things. And as we were saying, women or ladies tend to be more specific than men in the context of specific items like that. And I would generally advise that you do, as Martin said, a letter of wishes, which would contain a list of the items that you're giving to the various parties. And those items, you know, rather than relying on your children to fight it out amongst themselves about what they want, you know, amongst your items, I think it's a good idea to create the list, do the letter of wishes, and then with your solicitor, you put it into an envelope, you sign the back where the seal is, and it goes into the envelope with the will. And you know, it keeps things outside of the will, and it stops disputes. And you know, these items, I'll leave Martin to talk about the rest of it in terms of its tax efficiency, but it is a really good way to deal with specific items.
And John, as you do the will consultation, have you come across any family who comes and do the will and no children?
Yes. Yes, I've had a couple of those recently, actually. You know, maybe it might be a person, a husband or wife who, you know, who's a widow or widower, who would come to me and say, well, look, I have no children, but I have, you know, 20 nieces and 20 nephews and a load of friends who've cared for me during my lifetime. You know, how would you do it? So what I advise is, you know, in terms of the nieces and nephews, they come under the Class B threshold, so they are entitled to the 32,500 tax-free threshold. And then the strangers in blood, we call them, friends, can have 16,250, 16,250 tax-free. So it often comes to this sort of an equation we work out, and we might leave maybe say 50% to the family, the nieces and nephews, and maybe the surviving brothers and sisters. And then we might go, you know, we might say 10% to charity, and then possibly, you know, another 20% to friends and family, etc. And, you know, I suppose in the context of it, the person would estimate what the total estate is and figure it out to bring it to allow everyone to get a tax-free gift. So, you know, so that's what I'd advise in relation to people who don't have children.
Thank you, Joanne. Maybe I'm thinking there will be more question for you, but again, I just asked next question to Mujib Evans. Mujib Evans, you were discussing about the children is left after the, if they make the will or not through the family tragedy. Is any special benefit, or is the same rules applies to any children who are in special need or in long-term disability?
Oh, that's the same, because for example, if the parent has one able child and one disabled, he has the same responsibility. In the same way, the guardian has the responsibility towards disabled child as well.
But the disabled child is not going to be a normal adult.
That's right. So in the same way, if the natural parents are caring about that disabled child, that will be taken into consideration by the guardian as well.
And Martin, there is no tax relief on this kind of the special child of the on inheritance.
No, other than whoever is looking after the child gets what's known as the incapacitated child relief under their income tax. It's usually done that way, and they can claim any medical expenses and things against their income tax as well. Now, there is one other important point that I forgot to say earlier. If somebody is a minor child and they receive a gift or an inheritance from their grandparent, and if their own parent has died, they get the 335,000 gift. So in other words, if dad is giving money to a granddaughter because his son or daughter has passed away, as long as the grandchild is less than 18, they get the parents' tax-free threshold. But that's just a limited circumstance where a grandchild can inherit using the parents' threshold. It doesn't apply anywhere else.
Thanks, Martin. And Mujib Saib, any disadvantage to appoint a guardian?
No, there is nothing. There's a benefit. So no disadvantage for appointing a guardian.
Okay.
And Dr. Harun, there are a couple of questions actually. They're pouring in from everywhere, including our Facebook live stream as well. First question is from our chat that's outstanding. Please elaborate the sequence of asset left behind in order according to the Irish law, especially level where outstanding tax liabilities will be falling upon. Maybe Martin, would you have any idea about that?
I think that's one for Joanne or Faisal.
Oh, sorry.
Okay. Okay, Joanne, you like to answer, or you want to hold on and I ask the other question to Faisal?
Yeah, I'm not quite sure what that person is exactly asking, to be honest.
Okay, it's at 3:15, but I'll read it again. Please elaborate the sequence of asset left behind in order according to the Irish law, especially level where outstanding tax liabilities will be falling upon.
It also have to do with possibly, debts that the estate might owe. And again, Martin, you might
Joanne, if someone dies in testate, basically, I think is the question. How are the assets distributed?
Okay, right, here we go. So, so if you die in testate, okay. If you go and die in testate, I think I already talked about the spouse. So if your spouse then has predeceased you, it goes to your children. And then if you don't have any, if you've no children, no spouse, then you're talking about it goes to your parents. And then if your parents have predeceased, it goes onwards to your brothers and sisters. Obviously, if your brothers and sisters have predeceased, then it goes to your nieces and nephews, and onwards, and eventually, yes, to the state. And a really important point is if your estate is never administered and nobody bothers to come around and administer it, your estate goes to the state, including your land. And that's another really important point to note. That the state is the ultimate beneficiary.
Okay. Thank you, Joanne.
Thank you, Joanne. Faisal Sahib, do you have any question, Khalid Sahib? Yeah,
there are a few. There are actually loads, but very quickly.
Yeah, but we cannot answer everything, because every question because of this, but we can select the question what are important.
Sure. So this one is interesting. Like for those that have dual nationality with assets in both countries, do they have to make wills in both countries, like South Africa or Pakistan, as well as Ireland, or will foreign will be recognized in Ireland to distribute the assets?
Faisal Sahib, I think it was the same question if the person have the joint property in abroad or here. So I think you may explain this thing and you explain in the top in your talk as well. So if the assets are all in joint or in Ireland or in abroad, so how to apply this inheritance tax?
Thank you very much. If I can address Martin's question as well, the one that he raised very early on, that's quite an important question because I think it gives general understanding to everyone what a will is. Essentially, the law and the case law over time is that if a will is correctly executed, it will be given effect. The circumstances might be taken into account if it's challenged, but if it's correctly executed, the courts would normally, there will be presumption in the favor of the will. And obviously challenges then take place, but in ordinarily the will is given effect. And for that reason, there were a number of questions about Islamic will being able to stand in Ireland. Of course, an Islamic will is completely valid, and it would be attacked in a similar way, or the challenge of legal right share would be in exactly identical manner as it would be in the conventional will. So the signing of the will is perfectly fine. There is no exception. It's just how the rights are apportioned in the will. And if the spouse chooses her legal, does not elect her legal right share within 6 months, then the will be given effect, regardless of how it's apportioned. In terms of one will applying in another country or in a different jurisdiction, the short answer to that is no. Every country has its own legal rules. So if you have assets in different countries, it is good practice to have separate wills in each and every country. There was an issue raised in one of the questions about having assets in Pakistan. So I'll quickly address that. If you have assets in Pakistan, it is good practice to have a will executed in Pakistan, because the rules there are very different to the rules in Ireland. And there was a recent case someone flagged up to me in Pakistan. The Supreme Court had decided on a mother's right to pass on her legacy. The headline, I checked this case, and the headline in Dawn newspaper was just totally incorrect. It wasn't about the mother's passing on of the legacy. It's more to do with how long, what had happened. Basically, the father had given his estate to his sons, and the children's mother never challenged this in her lifetime, and her children were trying to challenge the will of the father, and obviously the Supreme Court decided that they couldn't challenge after the death of the mother. And therefore, it wasn't the decision wasn't necessarily to exclude the children of the mother. There was another question posed to me, and I think the slide would come up about Islamic portions. If you can bring that question up, and then we can address this. Would you like to read the question, or shall I do the honors?
Which question you were saying?
Question one?
Question one, yeah. I will read it out for you. How the distribution of assets is executed according to Irish laws in comparison to Islamic laws. If either mother or father passed away, they had 2 sons and 2 daughters. However, one of the sons who was married and had 2 children has died prior to father death, and grandchildren are minor. Assets include the house jointly owned by mother and father. So how they will.
The Islamic distribution is set out. It will be as follows. In fractions is a little bit complex, but the general principle is that the mother or the father, their right takes precedence, and then the remainder is then distributed amongst sons and daughters, 2 shares to the son and 1 to the daughter. There's a slight difference on the legacy to the mother and father. Again, I've set it out in fractions. That's how the estate will be divided. There is another issue if one of the children passes away in the lifetime of their parents. In Sharia, if a son or daughter passes away before the testator, their right, which is automatically given in the Quran, is then erased, and for their children or their issue to actually inherit, in that circumstance, wasiya would have to be utilized to apportion their share in Islamic law. In Irish law, if a child dies, their children normally inherit their share. However, if another relative dies, their share is taken back into the estate, and it's a residual legacy. So there's slight complication in there, and therefore the Islamic inheritance has considerably more detail, especially when there is a death of a child in their lifetime. Because it's a joint property, the distribution under Irish law is fairly straightforward. So I've set that out on the next slide. In terms of property, that's fairly self-explanatory. Joanne's really dealt with it in quite a lot of detail. I don't really need to address everything again. In terms of property abroad, especially in Pakistan, it's due to laws of Pakistan, it is better to have will in Pakistan that applies in Pakistan, and the circumstances are very, very different to Irish law. If you have relatives anywhere that you want to bequest something to them, obviously you can. The law, Irish law, allows for that. Aside that, I think that addresses the general principles. If there's anything more specific, then I'll address that.
Thank you, Professor. Again, there are a lot of questions coming, but we are short of time as well. So I'll take next 5 questions, and after that we will conclude the session. I asked one question to Martin, that if I transfer an asset to my son or daughter and it results in a capital gain tax liability, will they still have to pay full capital acquisition tax?
No, they will get a credit for whatever capital gains tax you paid. Now, that's on the condition that they hold the asset for a further period of time, unless, you know, revenue give a concession for whatever family reason or sickness or ill health. But in general, they will get a credit for whatever tax you paid on the asset on the same transaction moving across.
So one tax has to pay either the capital gain tax or the capital acquisition tax. Yeah,
you'll end up paying the capital gains tax, and they will not pay the capital acquisitions tax. They will get a credit for your tax.
And another question person has asked, that if I transfer an asset, and can it still retain some control on it?
Yes. And, you know, without going down the formal trust route, say you transfer an asset, it's worth 335,000, and your son and daughter, they're getting it tax-free. And you want to make sure they don't sell it the next morning and buy a Ferrari. Well, what you can do is you can put a charge over the property to the value of the property, or even exceeding the value of the property. So say you put a charge over it for 500,000, as if you had given them a bank loan. You secured the property in your own name, and if they try to sell it, the charge has to be released first. You register the charge with the appropriate authorities. In that way, any uplift in the value goes to them tax-free, and they only receive a gift or inheritance when the charge is removed. So it's a way of retaining control without actually being very formal about it.
Okay. And thank you again. Khalid Saab, do you have any question, or will I ask another question to?
We have one question on Facebook.
Yeah.
He's asking, please elaborate who qualifies as next of kin when in the absence of parents, spouse, siblings, etc.
This question can be answered by Mujib Sahab.
I think this was answered by the John. And
already answered.
They are asking about the inheritance, I believe.
Yeah.
Okay. And Mujib Sahab, can I, Khalid Sahab, that's okay, or you have another question, or
that's
I ask?
fine, I think.
That's okay. I have a question for Mujib Sahab.
Yeah.
And if there is more than one children in the deceased family, the court has to appoint guardian.
Yeah, in that scenario, you know that sometimes if there are more than one children in the family and those goes into the social care, and then foster carer comes to take, and sometimes the foster carer takes only one child, and the other two are one single child actually remains with some other foster care. So that's the drawback if there is no appointed by the parents in their life. So then the siblings are splitted actually, and they sometimes it's difficult for them to see each other.
Thanks, Mujib Sahab. And Martin, it's the second last question, and then we will conclude the session. Are there any category threshold available per gift, or is it once in a lifetime threshold?
It's once in a lifetime threshold, but that threshold can move up and down. In the past, it has moved down, but they're all moving up again as asset values increase. So say it's 335 now. In the budget in October, it might go to 350. Next year, it might go to 375. So always watch it, so that you're not wasting some valuable threshold headspace.
Okay, and that's very good. And what's advice to give if the people have different kind of the properties? Some properties are residential, some are commercial, some are agricultural land, farmland, or forest land. What's the tax?
Forestry can usually pass tax-free. Agricultural land, if the value of the recipient's whole property is 80% or more comprised of agricultural land, they can usually inherit that at 3.3% of the value. And for commercial, if you just have commercial property that's rented out, say like a shopping center, that's normal rates. If you have a hotel or bed and breakfast or some business that's operated within the property, and you own the property and the business, well, say a cinema chain, for instance, or a cycle shop, they can pass down, provided certain criteria are met. There's a 90% reduction in value, which means in effect that the tax rate on it is 3.3%.
Thank you, Martin. And the one question is the last question.
Dr. Khan, on that, somebody over the age of 55, if they're in business, they can transfer some of their shares in their business to their children or to people that were involved in the business up to the value of 750,000. And that can be done tax-free on them, free from capital gains tax. And also the person receiving it will benefit from the 90% reduction in value. So that's something that can be done around estate and retirement planning.
Thank you, Martin, again. And this is the question that I have asked in email. And this is the last question. This is just the explanation. I think Joan can tell you. As you prepare the people wills, how much it cost, and as you said already, it should be kept in safe, and any witness required at the time of the consultation.
Well, Okay, so just in relation to cost can vary substantially depending on the complications, how complicated the will is. But if anyone's interested in talking to me directly in relation to cost, I'd be more than happy to discuss it with them. And then I think you talked about witnesses. So witnesses, it's been quite complicated in the COVID times because I've taken a lot of instructions over Zoom. And then I've subsequently met people in all sorts of places, park benches, you name it. There's been, we have to be very, very careful about witnesses. That obviously the witness can't be a beneficiary. And that's kind of the golden rule. So, so we've had to grab out for witnesses left, right, and centre. And ideally now that we're getting back into the swing of things, generally people come in and two witnesses are required, and often it would be, a second party from my office would witness. I think that covers it. Question.
Thank you very much. And now I conclude the session by saying to this that the recording will be available.
Just one last question that was on the Facebook as well. What about the mortgages where the insurance doesn't cover the full mortgage, and what is the thing says about inheritance and tax matters for this kind of mortgage left behind by the deceased for the children and other people. So what law says about that thing? So
yeah, that's another really important one. And in my business, you're buying a property, you're taking out a mortgage. Generally, the mortgage has a life policy, or what's called blanked on that now. It's a life policy anyway that is attached to the mortgage, and it usually is of the same value as the mortgage, and a lot of them or most of them will decrease at the same rate as the mortgage decreases. So generally they pay off all the mortgage. There might be some time whereby you might have a commercial mortgage that doesn't pay off all the mortgage, all of the mortgage. So therefore the property is kind of left with a charge. It's left with a charge. And therefore, in order to distribute, you have to deal with the charge, which is registered against the property, and then distribute afterwards. I think that covers it.
I think that's covered. And thank you again for everybody. Particularly, I will conclude this conclusion by thanking to all speakers. Mr. Faisal Sadiq Khan, really nice talk. And Mujibur Rahman Saeed, really interesting topic you discussed. And John Mufti Sahib, really you give this a valuable talk on the Islamic views. And John Hoban, really you explained well with the simple words. And Martin, no doubt the text will be reduced if we come to you regarding this inheritance. The recording of this talk will be available on the YouTube, and the template we have made it after talking to our speakers, and the template will be available on the webpage of the Irish Pakistani Professional Associations, and the consultation and maybe discount available for our, if we go for the making the will from our panelists at their practice service addresses. IPPA, Irish Pakistani Professional Association, has tried best to clear the concept how to make the will in Islamic way with understanding of the Irish legal framework system. IPPA thanks to all his team members who really work hard to make this webinar happen. And I'm really thankful to the participant who really stayed on till the end of this session. We thought this session will be going to end in 90 minutes, but it's nearly 2 hours now. So thank you again, everybody, and Khuda Hafiz. Thank you.
Thank you.
Thank you very much, everyone. Thank you. Much appreciated.
Thank you.
Committee members will please stay on the